Hi, my name is Robert Hetzler, and I'm making this video today because I'm asked, after having done 2,000 or 3,000 or actually several thousand quadros over the years by attorneys, judges, or mediators, Robert, what is the biggest problem or one of the biggest problems that you see attorneys make or those drafting the agreements make when drafting settlement agreements? So I chose one today that I want to talk about, and of course there are several, and I've actually taught a class on this before, but in this particular instance I want to talk about not using the correct name of the plan. What I mean by that is, for instance, you may have a paragraph in an agreement that says the husband's retirement plan and the wife's retirement plan shall be divided evenly, and that's it. And in that circumstance, we're not necessarily sure what type of plans are in place. We don't know if the husband has multiple plans, if the wife has multiple plans, if the husband had multiple employers, which had multiple plans during the course of his employment, which was also during the course of his marriage, and the same could be true for the wife. So if you're not specific about what the plan name is in the agreement, then you run into all kinds of barriers when you try to implement the quadro and divide the retirement accounts. Let me give you a prime example. I've had a paragraph that says just that, where the husband and the wife shall each evenly divide their retirement accounts. Turns out in one instance the wife would just have a 401k, but the husband has a 401k plus a defined benefit plan from a previous employer that he was vested with, and maybe a 403 cash balance plan, or maybe he was in the military at some point and has a thrift savings plan. Well, when it comes time to divide it, when I talk to the clients and get some clarification about which plans are in place, because the agreement just says divide the plans, obviously the wife's position is, well, all the husband's plans should be divided. And the husband's position is usually, well, the wife only had one 401k plan, so I was just talking about netting my one 401k plan against hers and dividing the difference and figuring out, equalizing the accounts. So you can see we're not naming the specific plans and being as specific as possible in the settlement agreement, or the final judgment can obviously lead to discrepancies and potentially further litigation down the road. And another thing about it is, a lot of times attorneys will say equalize the accounts, and one account is a defined benefit plan and one is a defined contribution plan. That's inherently impossible to equalize those types of accounts when they're that different. That's a topic for another day, which we'll do a video on, I promise. But for right now, what I want you to take away from this video is that a lot of times when you are drafting these settlement agreements or drafting even the final judgment in response to the judge's request, you need to take the extra step and find out what the name of the plan is. And there's 3 different practice tips that I think you can take away from this. And one is, the best way to do that is try to talk to the employers, the former employers of all the spouses involved. Now, if it's your client, then obviously you may direct your client to do some of that discussions. If it's the opposing counsel's client, you may have to do that through some type of discovery process. But the bottom line is, you can find out through the employers what types of plans may be in place. And remember, this is important too, is if you had a client, and this happens a lot, I'm sure, you have a client that worked for the same employer, and that was the case about a year ago, don't just assume that because you have a new client, a new case, but he worked for the same employer, she worked for the same employer, that the same plans are in place. Because a lot of times, depending on the start date, depending on the level within the company, it depends on what type of plans are available. So one employer doesn't necessarily mean that they give universal plans to all employees. So you got to be careful. So the first tip is talk to the employers, both sides in the divorce litigation, and find out what's in place. The second is discuss with the TPA, the third party administrator. That's the individual that administers the plans. And a lot of times I hear from attorneys, Robert, I try to contact these people, they're argumentative, they're not helpful, they're difficult. And that, I think, used to be true many years ago, but I think it's changing now, because what's happening is they have a big incentive to try to cooperate initially, because they want to get it right the first time too. They don't want to have to continue to see amended order after amended order after amended order, or subpoenas or other types of discovery requests. So they have some incentive to try to get it right the first time. So I find in a lot of cases as the attorney for the client, you're able to simply make a phone call to the TPA, third-party administrator, and ask the hard questions. And a lot of times you're going to get very succinct answers and the answers you're looking for. Now, that's not always true, and in that case, if it's not true, certainly you, as the attorney, have the power of the subpoena and other discovery processes at your fingertips that you can use. Another and the final thing that I'll say, and probably the most important thing, is get a copy of the summary plan description. You'll hear that referred to as SPD. Summary plan description, or SPD, is the document that tells all about the plan, what the plan allows for, and every plan has one. So if you have a client that has multiple plans through multiple employers throughout the marriage, if he or she changed jobs 2 or 3 times and had 2 or 3 plans with each one, 401ks, SEP plans if they were self-employed, 403Bs, thrift savings plans if they ever worked for the government, any of those types of things, you're going to have a summary plan description for each and every one of those. So you certainly want to take the time to get those and review those, or get a Quadro provider involved early on to help with that process. But certainly you as the attorney, I recommend getting copies of those through the discovery process. We certainly get copies of those as part of our process, but a lot of times, or most of the time, we're involved after the settlement agreement's been signed, the terms have been negotiated, and sometimes we have to deliver the bad news that, you know, some of the things drafted in the agreement are an impossibility. So a lot of that can be avoided by simply following those 3 practice tips. And I think when you do those things, you'll often find the case, for example, that some of the plan names are ABC Corporation 401k plan, or ABC Corporation Qualified Pension Plan. And just inherent in the name of the plan tells you what kind of plan it is. So the ABC Corporation 401k plan, obviously it's a 401k, a defined contribution plan, and something that can be equalized, something that can be divided readily and allow for cash disbursement and a tax penalty-free disbursement. Again, other topics for another video. But also the most important thing to take away from that is when you do the discovery, you can find the plan names, and the plan names themselves will tell you what needs to be divided. Again, those are just some practice tips today. Make sure to use the correct name of the plan in the agreement and be specific in the agreement. Don't just say the husband and wife shall evenly divide the retirement accounts. Go through the process of finding out, put the burden on the clients if you have to, but certainly find out the name of the plans that are in place so that there's no disagreement, there's no ambiguity at the time that the Quadro needs to be implemented. I hope you found this video helpful, and we'll be making more in the future, and I look forward to seeing you.